Assalamu alaikum. In today's video, we will learn about the discharge of a contract. If there is any contract between promisor and promisee, then there must be in certain conditions when a contract actually become discharged or become ended up. So what are the conditions? We will learn about it today. So, according to the language of law, the discharge of contract is said to a contract is said to be discharged when contractual relation between the parties to a contract are terminated or comes to an end. There are two different phases. Either it will be terminated or it will be come to an end. So in other words, when the parties to a contract have either performed or are free from the task of performing their respective obligations as are arising from the contract. So what are these conditions? The first one is discharge by performance. So there are two main examples under the discharge by performance. The first one is actual performance. If the parties to the contract perform their respective promises in accordance with the terms of the contract, then it is said to be discharged by actual performance according to section 37. Like if there's a contract between Mr. A and Mr. B, and Mr. A has to deliver 1,000 goods upon rupees 1 lakh. So if we deliver 1,000 goods and Mr. B has paid 1 lakh rupees, now this is called the actual performance from the both sides. So the contract has been discharged because both parties have performed their actual performances. In type 2, there is attempted performance. Okay. If the promisor has made an offer of performance as per the terms of the contract and the promisee refuses to accept the offer of performance, then the promisor is said to be discharged by attempted performance. It is also known as tender. So it is equivalent to actual performance. In this performance, the promisor offers to perform his obligation, but the promisor refuses to accept his performance according to the section 38. Like Mr. A has uh, you know, Mr. A promised Mr. B to deliver 1,000 goods against rupees 1 lakh. So Mr. B offered to Mr. A that please done your performance, like deliver 1,000 goods, then I will pay this sum of money. Now Mr. A refused to deliver the goods due to any reason. Now, this is called the attempted performance by Mr. B, which is actually equivalent to the actual performance. Now, if Mr. A has refused to deliver the goods to Mr. B, so it means the contract has been discharged because the attempted performance has been done by the Mr. B and Mr. A has refused to perform. So in these two conditions, we can say the contract has been discharged by the performance either by actual performance or by attempted performance. The first one is by section 37 and second one is by section 38. Now, here discharge by agreement or by consent. Okay, the first one is a novation. Novation means the substitution of a new contract for an old one. The new agreement extinguishes the right and obligation that were in effect under the old agreement. Okay, so in according to the section 62, when a novation occurs, there is actually something new in that contract. Like Mr. A owes money to B under a contract. It is agreed between A, B, and C that B shall now accept C as his debtor instead of A. So the old debt of A to B no longer exists and the new debt from C to B has been contracted. So this is called a novation. Like you are, according to the contract, you are liable to pay back the loan to Mr. B because Mr. B has issued you a loan. Now Mr. B said, oh, do not pay me, just pay the remaining amount to Mr. C due to any reason. Now, this is called a novation. So, Mr. B has been discharged. The contract has been discharged between the A and B. Now, the contract is actually between Mr. A and Mr. C. According to the section 2, the fourth one is a rescission. It's a cancellation of a contract by mutual agreement of the parties. Okay, like Mr. A promised B to sell and deliver 500 bales of cotton on 1st November at his godown, and B promised to pay for goods on 1st December. A does not supply the goods, B may rescind the contract. because he has not received the goods. So, with a mutual agreement, the parties may come to an end by rescission. This is an alteration. Alteration means a variation made in the language or terms of a contract with mutual agreement. When this occurs, the original contract is discharged and a new contract is created. The parties in the alteration remain same under the section 62. In novation, the parties may be changed, but in the alteration, the parties remain same. Okay, so like if there's a contract that A has to deliver 1,000 goods against rupees 1 lakh, now maybe with a mutual understanding, they agree that A has now delivered 1,600 goods upon 1,60,000 rupees. So this is alteration. So they have been discharged from the previous contract and now buying one from the for the new contract. There's another thing that is called remission. Okay, in remission means accepting a less amount than the initial amount agreed. Okay, like Mr. A promised to paint a picture for B, and B afterward requested A not to do so. Uh, if agree is no longer bound to perform the promise. Okay, or you can say A owes rupees 5,000 to AOs actually be rupees 5,000. C pay to be rupees 1,000. B accept them in satisfaction of this claim on A. Now the payment is a discharge of the whole claim. So if any party accept the lesser amount than the amount which they have agreed initially, then we can say that it is called a remission. Again, a waiver is a unilateral act of one person that results in the surrender of legal rights. It amounts to releasing of a person of certain legal obligation or contract. It is very rare, like if any party do not uh, acquire the consideration which they have promised earlier. So this is called the waiver. And the last one is the promisee's refusal. If any promisee neglects or refuses to afford the promiser reasonable facility for the promise performance of the promise, the promiser is excused by such neglect or refusal as to any non-performance cause. So it is very simple. If the promisee is not going to perform his performance, then the promiser automatically will be discharged from the contract. So this is actually discharge by agreement or by consent. The first one was a discharge by performance. Now, discharge by law. So the first one is the death. Okay. On the death of the promiser, a contract involving the personal skill or ability is discharged. Like if in other contracts, the rights and liability of the deceased person pass on to his legal representatives. So if promisor or promisee will die during a contract and such contract possess personal capacity skills, then such contract will be discharged because no one will gonna perform such performance on behalf of such promisor or promisee. But if it is not related to the personal skill or capacity, then it will be enforceable by their legal representatives. The second was the insolvency. When the person's debt exceeds his assets, he's actually adjudged insolvent and his property is vested in the official receiver or official assignee appointed by the court. So such person cannot enter into a contract relating to his property, sue, or sued. Therefore, declaration of person as an insolvent person is discharged from his liabilities incurred prior to his adjudications. So if anyone declares insolvent, then he will be discharged from any current contract as well. Now, material alteration. Okay, material alteration is something very different. In material alteration, a contract is discharged if the terms of the contract are materially altered without getting prior consent of parties. A material alteration is one way changes following in a significant manner. First, when the legal entity of the contract or character of the contract or rights and liabilities of the contract. So, alteration which is not material or which is made after getting prior consent does not affect the validity of the contract. It is very important point. If there's a material alteration with a consent, then there will be no issue in the validity of the contract. But if there is no consent and there's a material alteration, then it will be constituted as a discharge from the contract. For example, A gives a promissory note amounting to rupees 5 lakh to Mr. B on August 16, and B subsequently endorses the same note in favor of C after altering the date from August 16 to August 23. Now, this is called the material alteration, and such contract will be discharged. Another one is the same identity. And when the promisor become the promisee, the other parties are discharged, like negotiation back in case of negotiation instrument, like creditor to himself become a debtor of the same note. How? Like A give a promissory note to B, B endorses the note in favor of C, who in turn endorses in favor of A. Here, actually A is both the promisor and the promisee now, and hence the parties are discharged. So this is called the same identity. Okay, now the here another one, discharge by impossibility of performance. The first one is the supervening impossibility. When a contract is valid at the time of formation and become impossible to perform subsequently, it is called affected by supervening impossibility law. What will be the effect? The contract become void when an act become impossible. Okay, or it also become void when act become unlawful, or a promisor is liable to compensate the promisee for any loss, or and the person is bound to restore any benefit received or compensate, like a restitution. So for example, A contracts to sing for B at a concert for 10,000 rupees, which is paid in advance. A is too ill to sing. Now A must refund 10,000 to B. This is called a supervening impossibility because he is ill and he cannot sing the song properly. Grounds of supervening impossibility. What are the grounds we can say, you can, where we can say it is also, it can be called as a supervening impossibility? The first is the destruction of subject matter. If the subject matter has been destructed, then we can say this is the case of supervening impossibility. Okay, like a music hall was rented out for a series of concerts. The hall caught fire before the date of the concert. So now this is destruction of subject matter, and it can be counted as a ground of supervening impossibility. Death or personal incapacity. If a contract is of personal nature, then no death, incapacity, illness, we have already learned about it. If there is any personal skin involved and such person is not available, it may be dead or incapable or maybe ill, then this is also the case of supervening impossibility. Declaration of war. And the declaration of war, at the time of declaration of war, the contract with alien enemies are either suspensive or declares war. We have already learned about it. Now, what are the cases where there will be no excuse for the supervening impossibility? The first one is the difficulty of performance. If the performance of a contract becomes difficult, more costly, or less beneficial than agreed at the time of its formation, a contract will not be discharged. Okay. Why? A agreed to supply gold within a specified time. He failed to supply in time because of government restrictions on the transport of gold from quarries. Now here A will not be discharged because the gold was available in the open market from where A could have been have obtained it. The second is a commercial impossibility. When a contract becomes commercially unviable or non-profitable, it is not said to be discharged. Like you have contracted Mr. A for good for 1,000 goods, which he should purchase at rupees 100 and sell you at rupees 120. There will be a markup of rupees 20. But suddenly, after the contract, when goods become more costly, like the purchasing price for the promise is now 120. And if we sell the same to you, then there will be no profit. So still he is not discharged, he has to do the same. Default of a third party. On default of a third party on whose work the promises relying contract is not said to be discharged. During the strikes, lockdowns, or civil disturbances, you are not discharged from any your contractual obligations, and it will not be counted as a supervening impossibility. If any there's any contract that is partially become impossible, then still this is not a ground of supervening impossibility. You will have to perform the contract. Supervening illegally, if the performance of the contract become unlawful due to a change in the law after the formation of the contract, then the contract is said to be discharged. Okay. Uh, Now the last one is the discharge by, second last one, discharge by lapse of time. And in this heading, we have the limitation period. If a contract is not performed within a period of limitation, then it is discharged as the parties cannot legally enforce their rights. So after the expiry of the limitation period, the debt becomes time when and hence cannot be recovered through court of law. We have actually this time bar debt. Okay. There's another discharge by breach. So in discharge by breach, the first one is the actual breach of contract according to section 38. When one party refuses to perform his performance, then we can say it is actually actual breach of contract. Actual breach of contract. Actual breach has actually two ways: the course of performance and due date of performance. If any party has performed a part of the contract and then refuses or fail to perform the remaining part of the contract, it is called actual breach of contract during the course of performance. Because during the course of performance, it means it has already performed the partial performance, but the remaining performance has been refused by that party. And the second one is due date of performance. If any party to a contract refuses to fail to perform his part of the contract at the time fixed for performance, it is called an actual breach of contract on due date of performance. So you must have to differentiate these two type of breaches: either one breach of contract within a course of performance or on due date of performance. Now, anticipatory breach of contract, there is actually no breach of contract actually happen, but there are circumstances which may be in which the other party may presume that it will be happen in the future according to section 39. So a party may be intended not to perform the contract in the following two ways. The first one is refusal to perform promise or disable to perform promise. Okay. So when the party to a contract has refused to perform his promise or become disabled or has disabled himself from performing his promise in its entirety, then we can say this is anticipatory breach of contract. Like Mr. A has contract to Mr. B that he will sing a song, he will sing in his theater throughout the air. Um, in evening, but suddenly he become aware that he is now signing the same contract with Mr. C for the current year and for the same time, like in the evening. So Mr. A has a right to sue him or get a stay order or get an injunction in order to enforce his current contract, because if he will do so, then he will lose his audience. So this is all about the discharge of a contract and what are the conditions when the contract will be discharged. Thank you so much. Allah Hafiz.